Hi, everybody, and welcome to the September 2020 edition of the Third Fridays podcast. My name is Christian Cison, partner here at Lois Law Firm. And, you know, we've kind of come out of the COVID-19 pandemic in a way that our clients see us stronger, bigger, faster, and just a better service provider overall. And our last few episodes have really demonstrated that. We did have some discussions about the developments of COVID-19 and its relation to how we practice law in our industry. We've had clients come on as special guests to talk about their reactions, their opinions of how claims should be handled going forward. And we've capped it off with a couple of episodes that talked about how we are doing as a firm and giving you an inside look into how growth is being still pursued in spite of a pandemic that can slow other people down. And one episode talked about some wins across the firm, and they keep coming because we still keep the mindset of defending clients and defending employers with an aggressive mindset, despite our adversaries or a judge or a board determining that an issue is not right for litigation due to the pandemic. And last month, most recently, we actually had a mock podcast, and I say that because it was the final stage of our annual mock trial competition, where finalists engaged in oral argument, pretending that I was the mock board panel, which I don't consider to be a very hard job, but it's not a job that I want at any point in my life. But basically, we've now reached this point where we're reacting to things that the board seems to be, for better or worse, working on the fly. And here to discuss some trends and recent development on a particular defense is an attorney at the firm, Addison O'Donnell. So Addison, welcome to the show. And, I guess to start off, you did perform very well in the mock trial competition this year. So any thoughts about that before we head into something more pertinent?
Sure. Thank you for having me, Christian. Um, you know, One thing I have to say is that you don't throw compliments around too often. It's like manhole covers, so I am greatly appreciative of that. Thank you. I love the mock trial program. It's one of the best parts about Lois. It's the best part about the summer at work because we basically not only get to show our stuff to each other, but we learn things from one another. One thing that I constantly pick up from other attorneys is differences in style, right? I tend to be a little bit more theatrical. I tend to be a little bit more outspoken, a little bit more loud. There's a running joke at the office that if you can hear a bellowing laugh from across the building, it's probably me. But that being said, one thing that I picked up from this is actually being able to articulate something in a more calm way might accentuate the things that we would normally be using as a tool for zealous advocacy. So I absolutely love the mock trial program. It's really, really innovative. It's cutting edge, and I don't think anybody else does it like us.
Well, yeah, I think we're always trying to push a culture of learning here. And despite our many years of experience in defending employers in this context, the law will change. And, I think that's kind of why, I could probably speak for you on this as well. One of the reasons why we signed up to be attorneys in the first place is that you're always challenged and you have to constantly adapt because case law will be made every so often, and you can't rest on your laurels. You have to continue to really be okay with not knowing the answer in order to eventually get the answer, because someone will tell you, a higher court or a state legislature, that the way that this has to be adjudicated is now different, and we always have to pivot and make sure we're representing our clients to further their best interests. So, in talking about that, what I wanted to discuss today was, I used this word earlier, the erosion of the labor market attachment defense. Now, Addison, you started at this firm actually as a law clerk. So, I mean, I can remember the times where, you drafted labor market attachment questions for an attorney to go in and litigate. You've drafted summation briefs, appeal briefs on the issue. Once you became an attorney, you litigated before judges and against adversaries on the issue. And more recently, you've actually penned some appeal briefs on labor market attachment to the third department. So maybe to just give the first-time listeners, because there are always some, a little primer or a background on the defense. What would you say is labor market attachment, and how does it help our clients?
Sure. So labor market attachment, in my view, is the ultimate check on claimants in workers' compensation law. It is a great defense for carriers to ensure that claimants aren't receiving benefits either in bad faith, or that the claimant is merely earning because he or she doesn't want to work. After all, the overall grand scheme, the overall design, the architecture of workers' compensation indemnity benefits is that it is a system of wage replacement and not necessarily wage substitution, right? But for the claimant's work-related disability, the claimant would be theoretically working and would be receiving wages that the carrier is theoretically replacing. So that being said, if a claimant is legally found to be able to work, i.e., if the claimant has a partial disability as a result of the medical evidence, as a result of zealous defense and zealous advocacy, then the claimant bears the burden of demonstrating to the judge, hey, I'm still part of the labor force in order to receive these indemnity benefits. And this applies to permanent disability, permanent partial disability, and temporary partial disability. So basically, what we do for our clients is to make sure that the claimant is actually attached to the labor market, right? First, the way that I approach labor market attachment defense is, has the claimant even proffered, good evidence, right? If I took a piece of paper and just wrote that I did something, did I actually do it, right? And to drill down on that. And the other side of the coin is common sense questions for our clients, for our clients' interests, right? So we can ask the claimant, hey, why'd you apply to be a veterinarian's assistant? Have you ever had any experience with animals? Have you ever had any experience in a medical setting? So basically, the end game of this is that if the claimant was found to demonstrate attachment, right, to provide a timely, diligent, persistent work search, then the claimant will receive awards. And if it is shown that the claimant did not demonstrate attachment, the claimant doesn't receive awards and is found not attached. So that's labor market attachment in a nutshell. There are many thorough and many different ways you can go about in unraveling it. But really, in my eyes, it is the grease in the wheel of the workers' compensation system.
Yeah, I would more or less agree with that. I think you bring up temporary disability and permanent disability, which is a little bit overlooked because it's more often used in the temporary disability context, but before a claimant reaches a permanent partial disability and is classified with a loss of wage earning capacity, it's the employer's last opportunity to litigate attachment before that classification. So a good caveat there to include permanent disability in that discussion. Now, normally, it's not that hard of a concept to really litigate. A lot of times I do stand on this virtual soapbox, and I do say that we have the best tools and the best talent to finalize a determination that's favorable to our clients. But, on the surface, what you explained, getting a client to understand that when a claimant is released to work, he or she should look for said work, is not really something that takes a rocket scientist to figure out. We go in there, we make our proofs, and we get benefits suspended when the work search is inadequate, or when the vocational rehabilitation is not active or continuing. COVID-19 has changed that. Many things, added to the list, right? Labor market attachment. I'm pretty sure that our wonderful governor, despite your political feelings, has probably not thought that labor market attachment in the workers' compensation context would be affected by this, state of emergency. And I'm putting state of emergency in air quotes here, as we sit here on September 2020. But what has COVID-19 changed as far as the board's response to requests to litigate labor market attachment?
Sure. So the board panel, is definitely an arm of the executive branch of the government, an arm of Governor Cuomo, right? So on March 7th, 2020, the governor issued an executive order declaring a disaster emergency in the state of New York. It's still ongoing as of this date. Subsequent executive orders have demonstrated a need to extend this period of time. And during this emergency period, with regards to issues of labor market attachment, the board panel has directed law judges to adjourn the matter and address the issue of labor market attachment when the emergency period is over. However, this is not necessarily just, it's not necessarily stable or predictable, because then our clients are without a defense. So overall, the board is now performing these mental gymnastics as to prevent any awards from even being touched or suspended, and prevent our clients' fair and entitled interests to be forwarded. And you bring up a good point that it's Governor Cuomo issues an executive order, and all of a sudden the board panel ignores almost a decade of jurisprudence in the judiciary. And so there's also this checks and balances issue here, where we don't know who we're listening to. Are we listening to the president, or are we listening to the governor? Are we listening to the courts? Is there something that doesn't make sense between these two bodies? And the founders thought about this, and we still struggle with this today. So that's just an overview that during this emergency period, the board usually, I haven't seen anything to the contrary at this point, finds that the claimant may indeed conduct a job search, but the board is not requiring the claimant to demonstrate attachment in order to maintain indemnity benefits. And the board often says at the end of every board panel decision, the board will review this requirement upon the governor's declaration that the emergency period has ended. And so that's really an overview of what's going on in terms of COVID, before we dive a little bit even deeper into that.
Yeah, and there are definitely some practical and legal problems with this determination. One, from a practical point of view, you and I have litigated labor market attachment plenty of times where we are cross-examining the claimant on his or her work search or his or her vocational rehabilitation. And how many times does a claimant in 2020, no matter how old he or she may be, give a completely in-person physical job search? I would say it's very, very close to zero, if not zero. So practically speaking, the idea that a claimant cannot conduct work search during the COVID-19 pandemic is just, it's incredibly wrong, first, and it actually would go against the logic of any employer that is either A, conducting business, or B, has hired any employees since Governor Cuomo's emergency. The same edict that never specifically mentioned the Workers' Compensation Board or labor market attachment. Of course, why would Governor Cuomo spend time on that? He wouldn't. So to interpret it this way is practically problematic. And legally speaking, the decision to hold it in abeyance is so understandably frustrating, because what they basically do is say, since I'm not making a decision that you're not attached or attached, I'm not really stripping you of the defense. You can just bring it up once the state of emergency has been lifted. And now you're bringing in the political aspect of this, because who has the ability to remove the state of emergency? Is it anyone at the Workers' Compensation Board? No. It's the people in Albany. And as a protective matter, as a health initiative, how soon is that going to be lifted? So those are the problems that I see initially. Do you see any others maybe that I'm glossing over? Because when we get to the point of having to advise our clients on how to react to this, we first have to understand what the problems are. So do you see anything else that I didn't summarize for our listeners on the problems associated with that issue?
So you said something that particularly struck me. The fact is when is that date when the claimant is determined to not be attached, right? When is the appropriate date of finding that the claimant had not attached to the labor market? Is it the date in which we first notify the claimant? Is it the date where the evidence that shows a lack of labor market attachment is submitted? The board panel is wrestling with this. The third department released a case in June, this past June, Bruno v. World Trade Volunteer Fund. Third department. It has nothing to do with COVID-19. It's from way back in 2018, but it opens the door as to when carriers are able to litigate the issue of labor market attachment once the emergency periods are over. And so the third department believes that the date that the evidence shows a lack of labor market attachment when that's submitted should be the date in which the claimant's found not to be attached. The board panel subsequently took Bruno and ran with it. The board panel said that appropriate dates are the date when the claimant submits the evidence, right? The forms C-258, which does or does not show attachment. The date that the law judge sets by which attachment must be submitted by, and then nothing's submitted, right? We often see, claimant is to submit evidence of labor market attachment 60 days. Well, once that 60th day has passed, once we have told all of that time, that then shows that the claimant's not attached. So basically, I like getting into the nitty gritty like that, because when it comes down to brass tacks, the carriers are going to say, so what are we expecting with awards? Are we expecting it to be suspended the date of the hearing once the emergency period ends? Are we expecting it to be the date in August when we first raised the issue of labor market attachment? And the law is a little unclear. No doubt that the Third Department, the Appellate Division, will have a flood of litigation, a flood of briefs. You've alluded to this. We have one pending on their docket as we speak to basically figure out the nitty-gritty of labor market attachment. But that's, you summed that up in a nutshell. That's very good.
And here's where, we talk about, a system that benefits claimants already, and the initial response, while I'm appreciative of a response that is quick and determinative, sometimes moving too quickly without, reasoned discourse can be, affecting the system as a whole. For example, the board went to great lengths to amend permanency guidelines in 2017 and 2018. And what came out of it was actually a document that is more befitting of the current medical field we have in today's world, not the system that was dreamt about when workers' compensation first became a thing in the early 1900s. And here, we tell a claimant that you don't have to always go to your doctor every 90 days. We tell a claimant you don't have to attend all of the IMEs that a carrier and employer are entitled to schedule. And in regards to what we're talking about today, you don't have to look for work when either your doctor or a judge says that you do. And so you don't have to do all of these things, but employer, you still have to pay the claimant. And that's what we're really struggling with here. And, in talking about this issue with you beforehand, we touched upon a few things that can help our clients. And how would you say clients can be advised during this kind of determination by the Workers' Compensation Board in New York?
Right. So, I'm taking a page out of Christian Sison's playbook when I say defending from day one is literally the only key, the only strategy that will work. If we develop a record at every single hearing, if we request across the claimants at every hearing, if we continue to litigate the matter, and we continue to develop a record, we leave a trail of breadcrumbs, then we would best defend carriers. Claimants will forget hearings as to what was said, what was done. We could argue, one thing to the law judge at a later hearing that the claimant may have denied beforehand. So really, in my opinion, I think the way to do this is through the judiciary, right? The executive will not suspend the emergency periods. It's just not going to happen until, the executive's prerogative, until the Governor Cuomo says, okay, I'm done, right? It's playing to my preference that we should, find a good case, appeal to the Third Department on the legality of a board panel's decision. When a board panel says, "Oh no, we have to wait. We have to wait till this is over," in conjunction with other substantive issues, right? It just seems silly. It just seems silly that the board will go through hoops and will only look at one side of the system when carriers will always be in the system. Claimants come and go, so it doesn't quite make sense to me that the board panel is administering the law in an unfair and quite frankly unpredictable way. But, you know, in my opinion, I think what needs to be done is going through the courts, submitting to the judges at the appellate division in Albany and saying, look, the fact that the board panel is suspending law in favor of a very broad, as you've mentioned, a very broad executive order does not make legal sense, and it also slights you, your honorable judges. There's an important checks and balances question here. And the country looks to New York for workers' comp law, and this is no different, right? So I think enveloping your labor market attachment issue with other issues that are favorable to the carrier, right? If the facts are so clear, if the claimant's defense or the claimant's strategy was so off the mark, right? Then we could actually change the law.
Yeah, I think you bring up two good points there, Addison. One, first and foremost, if you do have appellate arguments to make that are more substantial to your case that you're already going to be making, right? We're already going to the board panel, or we're already going to the third department on a particular issue, then keeping the status quo with labor market attachment at hearings, creating a record, and using it as an additional argument isn't going to hurt you, right? If anything, if you do it correctly, then you may be able to go to the third department for a greater cause, but then get a more ancillary benefit that has wide-reaching availability to the industry as a whole. So I'm certainly on board with that. I think the harder part about it is when labor market attachment is the only thing going in your case. What if everything else is kind of at a standstill, or there really are no appealable issues? And that's what really bothers me the most, where our clients are getting really railroaded by this administrative determination, and we have to think about the practicality and the cost of doing so, because it really is a determination of where we are today and where we think we're going to be by the time we file a third department application or submission. So if we go to the third department, that means that we have lost at the board panel level and we can no longer withhold indemnity benefits as a result of the pendency of a further appeal. By going to the third department, there's an additional cost that is not really the same when compared to going to the board panel. Printing, binding, filing, legal, proposed record lists, motions to dismiss. The two of us dealt with a motion for poor person relief very recently. And that type of practice puts a dent in employers' pockets. So I think about it like this, where if it's possible that we're still in this, and again, using air quotes, the state of emergency, by the time a third department decision is rendered on the issue, and labor market attachment is your only real item to throw in the rowboat as a grenade to the other side, think about the fact that you're still going to be paying benefits throughout that whole time. It's very, very hard because it's not our money. And maybe there's some other opportunities to close the case elsewhere that we can't foresee on any particular claim today that may be apparent tomorrow. But sometimes I think about how if we could theoretically be in this position 1 year from now, we're going to wish that we had filed that third department appeal when we have that prototypical case that you mentioned. So just some few thoughts for our clients to think about on this September day in the year 2020. Addison, any final thoughts for our listeners before we sign off?
Sure. So, here at Lois, we are the most aggressive. We provide the most innovative defenses. Um, I do want to dovetail off what you just said, Christian, with third department appeals. Look, the stakes have to be high. It has to be the right case. We have to balance the client's wants and needs. But Christian can say this. I can say this. A few other of my colleagues can say this. We have quite an understanding of third department appellate practice. I mean, our adversaries on the claimant side, the attorney general, they are quite chaotic. They have no idea of the rules and what the procedures are. And here at Lois, we have it. We have it down pat. So while indeed the stakes have to be high, there's also a certain level of trust that you need to have with your client in saying, hey, this is the right case. This can not only help this case, but your 50 others, even ones where we're not even there for you. Um, but of course, we should be there for you. We should defend from day one. So I really appreciated being on your show. I love talking about labor market attachment, and I love talking about workers' compensation jurisprudence. Thank you.
Well, I guess that is a great way to sign off. So for Addison O'Donnell, this is Christian Cison reminding you to defend from day one, and also reminding you, thanks to Nicholas Fortino, that Third Friday's podcast is your choice, your first choice on this very day. Thank you, and see you next month.